Now, because of the reliance on case laws, you need to keep track of the law. Keeping track of the law is the fifth thing you would need to do. Now, there are easy ways to do that. Now, when I say keeping track of the law, it also means keeping track of what is happening in law and also in policy. You should be aware that the national IPR policy was out earlier this year, and it's a very comprehensive document detailing many things about where we are heading, especially in the IPR field. And interestingly, and which is good news for all of us, is that the government has kind of indicated that they will be conducting the qualifying examinations at regular intervals. Now, this is a path-breaking statement because the last patent agent examination was conducted in May 2013. So there's been a gap of more than 3 years. So that is good news. So you could expect the exam to be conducted in regular intervals. Now this is mentioned in the policy document. We also had recently the Patent Rules 2016, which I told you about. So the law is dynamic, not only in the way in which cases come out, it is also dynamic in a way in which the act and the rules can be amended from time to time. So if there is an amendment to the act or the rules, those are big things which will anyway catch your eye. But there are a host of guidelines and notifications that the Patent Office may issue from time to time. For that, you need to keep tracking what the Patent Office website is coming out with time and now, including the fact that when this exam is going to be. When I last checked, the date was not notified except for a statement that it will be before December. Now, before December could be November, it could be September and October too. It could also be August, but they normally give sufficient time for them to prepare. It's an all India examination and quite a lot of logistics need to be arranged. So you could expect reasonable time, maybe a couple of months for after the date is notified. So keeping track of the law, as I said, is not just keeping track of policy, keeping track of amendments, keeping track of cases. Those are the cases which are which come out of the High Court, Supreme Court, and the Intellectual Property Appellate Board. Now, Indian Qanun is one favorite place where you can find the High Court and Supreme Court cases. There are not many Supreme Court cases in patent law, far and few. High Court, yes, some amount of cases are there. They keep coming all the time. IPAB, the Intellectual Property Appellate Board, has on its website all the orders it has ever passed since it was created. So that's a great database you can use. And Patent Office itself, if you go to the Patent Office website, there is a page called Controllers Decisions. You can click on it, choose the sections where what you want to do or the parties who are interested in, and it will throw you up some results. Or you could just put the date and it will show all the decisions that the Patent Office has given. Now, one thing which we had created as a part of the work I do as the MHRA IPR chair is we have created a small database of patent opposition decisions, and we have put it on patentfastreporter.blogspot.in. It's a temporary hosting, soon we may be moving to a much more sophisticated place, but right now it's there. It has the entire decision from 2005. To be frank, there were no decisions in 2005, but we say because that's when the new regime took place. We have all the decisions from 2005 to 2015 in one place, more than 180 decisions. Most importantly, we have written an abstract. So you need not read the 70-page, 100-page decision. You could just see the abstract and come to a conclusion of what we are doing there. Now, you could also rely on so keeping track of the law involves all these things. You have to essentially look at following decisions of the Patent Office, and that's a great way to understand the mind of the Patent Office, following their decisions, because there is something called the manual which the Patent Office has released, which has some bare details or details which are not there or which you can't find in the Act and the rules, but the decisions are a great way to understand the decision-making process in the Patent Office. So what we have done on that website is we have put all the decisions in the original form in a PDF, in a viewer. The PDFs can be viewed on the viewer, And we have also provided the abstract on top. So you read the short abstract in 5-10 minutes, you will get the essence of a 70-page decision. So it's a great tool. I mean, I'll also tell you why. You may ask me, is all this required to take the exam? The short answer that I want to give you is, I mean, it relates to two things. One, paper 1 is Patent Act and rules. Yes. Paper 2 is drafting and interpretation. Keep that in mind. So interpretation can be anything on patent law. It's not paper 3. Part 3 is viva voce. You will be questioned on probably anything on patent law. It could be anything. Now, and as I see it, I don't see the objective of training somebody to crack the exam as a short-term, finite objective. I don't see it that way, because what happens, you qualify the exam. You need to become a practitioner, right? And you need to become a person who can be proficient in patent law. So we are not looking at this as a one-off thing. And I would not be right in telling people that you clear the exam and then the world will open up to you. Unfortunately, that's not the case. You will just clear the exam to find that there's quite a lot of catching up to do and to be abreast with the law. And you are embarking on a new profession, and this new profession will demand you to have proficiency in the law. So this is not just for you to clear the exam, but it would also, keeping track of the law will also make you a better professional.